Well, now we turn our attention to, it's still a legal matter anyway, but it's got to do with River State, as you may be aware of the Supreme Court ruling on that particular judgment. Let's bring in Richard Mokocha, who is an associate professor of law, University of Port Harcourt. He's also the MBA chair, Omoku branch of Port Harcourt in River State. Good morning, Prof. Thank you for joining us today. But
thank you, Chamberlain.
Right. Yes, we do know that the Supreme Court has ruled, validating the October 10, 2018 judgment of the River State High Court, Justice Soho's inclusive. But, you know, before that particular ruling, there were different schools of thought, because eventually the court said they struck out several applications, which they would explain to us in 3 months. But before that judgment was given, did you think that it was, let me use the word, infallible before the Supreme Court ruled on the matter?
No. So long as we are speaking about the law and the position of the law, I did not think that, I do not think that that judgment has any flaw. Neither did I think that the Supreme Court should have been saying anything, because the Supreme Court had been consistent on this matter right from October when it gave the interlocutory judgment. It's clear for anybody to see that it warned, even in the October judgment, that you are not expected, or you should not expect to benefit from your wrongdoing, even in the future. So it's clear. That judgment is sound, is consistent with the facts of the situation.
What does that make of the other party? Because the APC had gone to court saying, look, they don't think that that is the case, because they thought that they had a chance to argue some of their cases based on the arguments that they had put forward over representation and the likes, but eventually the Supreme Court thought otherwise. So was it a wrong premise? Because they cited some authorities why they thought that they had a chance.
No, I think that that expectation was wrong and not founded on law. Because if you consider what was an issue, it's about your wrongdoing, and there is nothing you're saying about jurisdiction that affects the fact that you did the wrong thing, and that the Supreme Court has already affirmed in October that the actions of the court was right. So how can you delude yourself and they believe that, oh, you can raise some argument about jurisdiction and it can go somewhere? Even Section 46 of the Constitution gives to a citizen who feels that his right has been infracted the right to approach a federal high court or high court of the state to seek enforcement of his rights. And what we are talking about is participatory right of the citizens that were involved. So I think there was no basis at all for the issue of jurisdiction that they were raising.
So as it is now, perhaps giving us the benefit of hindsight, since you followed the matter, if at the time that the court had ruled that they stay action, saying that the executive that emerged were not valid, if they had stayed action, do you think they would have been able to conclude the matter and then still have time to conduct a fresh primaries and meet up with the time?
Oh, yeah. Certainly. The court was working on an issue that had a timeline. And just the way the appellate courts have done in this matter, the court would have ensured that the case is concluded in time enough for them to be able to conduct their processes. The rules are there, yes, but we pray the courts in appropriate circumstances, and the courts consciously consider the circumstance in which they are operating, and they can quicken the process. So, I mean, that certainly would have happened, and all these problems would not have been there for them.
Well, this is huge because, I mean, that Supreme Court judgment automatically invalidates the May 19 and May 29 local and state government congresses that the party conducted in the state, which then means at the moment that, look, they can't have any representation. But there's still some matters that is before the court saying, well, the Magnus Abbey faction are thinking, well, since we were not the ones who disobeyed the court's order, why should we then suffer for those who disobeyed the court's order? Do you see any logic in some of these things? And I know some of the matters are before the other court, so we'll leave those as areas. Do you think that there's a point, perhaps?
Certainly. Their point is valid. The Supreme Court judgment, perhaps we should clarify this. The Supreme Court judgment affects APC to the extent that it's relying on those candidates that are invalid. It does not stop the validity of the other primary. Fortunately, that primary was held within time and in accordance with the law. And so it doesn't touch it at all. When we talk of the matter being over, the matter is over for all the candidates elected from the indirect primaries. The matter is not over for any other member of the party that was not part of that disobedience.
Yeah, but Prof, if as we know, they always tell us, and because I've said it too, it is the political parties that present candidates.
Agreed.
So if the party then comes in this case and says, well, these are the people we recognize and attended the congresses, albeit, well, invalid as the court has ruled now. So if the other faction says, well, we were legit, and the party says, no, we didn't supervise, monitor, recognize theirs, will the court be right in validating them, contrary to the party's position and framework to validate them?
You know, what we need to understand is that there was division in the party. There were two directives, one from the National Executive Committee, one from the NWC, which is subordinate to the National Executive Committee. And the two factions acted, one according to the NWC, one according to the NEC. So both of them acted according to some standing directive of the party. And in the circumstance, the only valid thing the party could have done is hold the direct primaries. However, what is important for us at this stage is between what the party is saying and what the party members are saying. In Oresi versus PDP, the Supreme Court has held that where there was such competing primaries, all done within time, within the time frame that primaries should be done, that the court has a right to determine which one is valid. And the court held in that case that a primary is held by the state executive. It's a valid primaries of the party. And so, considering that the primary was held by the ESCO, that the ESCO of the party, that the courts, from the High Court to the Supreme Court, has affirmed there is a valid ESCO. Considering that it was held by such ESCO, relying on the 2016 decision of the Supreme Court of Oresi's case, they should be able to canvass the argument properly. And then more importantly, this contestation was on, even at the point that the party presented the candidates that it presented from the two primaries. And so it's open to the court to determine which one is legitimate. The agitation was already on, and it's a course of action that is pending before the courts, and the courts can make a determination on it at any point.
Yeah, but what do you mean when you say competing directives from the party? Because I thought it's the NWC that will send members to go supervise and conduct elections, and not the SWC.
Yeah, not SWC. The NEC of the party had reserved Rivers State or identified Rivers State as one of the states that are to go by direct primaries because of the matters that were pending in court in the Rivers State section of the party. The NWC, which is lower than the NEC, decided subsequently to put Rivers State into the section that is to hold indirect primaries. Now, for purposes of direct primaries, let's make this clear. The law does not require supervision. If you understand what is involved in direct primaries, voting will take place in every ward of the party that is in the constituency. So if you're talking of governorship, National Assembly, and State House of Assembly primaries, you're talking of voting taking place in all wards of all local governments of the state in question. The law does not require NWC supervision of that. The law requires only what is in Section 87, subsection 3, that the party ensures that all parties, all aspirants have equal opportunity of being voted for by members of the party. And if you want to ask yourself in this scenario, where does the proof of that lie in the direct primaries? You simply look at the result. And from what I've seen so far, all aspirants were voted for. That is conclusive proof that they had opportunity of being voted for. The law does not require the party to direct the NWC to go and supervise direct primaries. That is for indirect primaries. Subsection 7 of that section 87, which gives the party power to make regulations governing the conduct of primary, talks of parties that adopt indirect primary. that they shall make provisions in their constitution and provide guidelines by which the indirect primary will be processed. It's not applicable to direct primary. Direct primary is governed only by subsection 3, which simply states that they should ensure that all aspirants have equal opportunity of being voted for.